It's been a crazy day.
It has been. It has
Oh, yeah, computer not working, nothing working. All right. Where are we? There was a referral to Veterans Treatment Court and
So yes, with regard to that, my client was out on bond at that time and he was without a home. So they were unable to reach him. He did miss his court date by 1 day, so he had an FTA warrant issue, so he's been picked up. He's asking that his bond be reinstated, which I told him might be unlikely since he had missed court, but I'm making that request. But we've already spoken to probation about having him evaluated while he's in the jail and maybe asking for a reset. 5 or 6 weeks out is what they're saying the wait time is. They said they're rushing him special for you. So if we could get the referral, that way we could get an answer as to whether or not he qualifies. Because I think the case will work out one way or the other. We just need to have that answer.
all right, so Ms. Ferguson, I need a 5 to 6 reset date for Veterans Treatment Court evaluation.
Yeah.
And counsel, if you want me to hear the bond issue for that one, you have to file a motion because you know the laws have changed.
And I also signed the discovery acknowledgement in both cases so that we're ready for everything, Judge.
March 2nd, Judge.
Okay,
All right, and if you want to talk to them, maybe they can do it earlier.
we'll push them. Thank you so much.
All right, thank you.
Okay, see.
Have a seat, sir.
All right, who's here on Andres Hernandez? Andres Hernandez? Court is calling 2025 CR 014110, State versus Andres Hernandez. Could I have parties announced?
Lauren Espinoza for the state.
Rafael Leal for Mr. Hernandez.
And you, Mr. Hernandez?
Yes, ma'am.
All right, you've had a chance to have everything explained to you?
Yes, Your Honor.
All right, counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Hernandez, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes,
Counsel, do you waive the reading?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, state needs to waive the habitual offender enhancement allegation.
Any objection?
No objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
yes, Judge.
You're charged with possession of a controlled substance penalty group 1, less than 1 gram in a drug-free zone. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Correct, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is.
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promise you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count 1, waiving the enhancement. They're asking that your punishment be assessed at 2 years in the prison. There's $1,000 fine, and there are no applications. Is that correct?
Yes, Your Honor.
Any objection to the court changing the plea bargain paperwork to reflect that there are no applications?
No, Judge.
No, Judge.
All right, did you understand that to be the plea?
Yes, Your Honor.
Defense, that's the plea?
Yes, Your Honor.
State, that's the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, I understood, Your Honor.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
Yes, Your Honor, state offers State's Exhibit 1 in all attachments.
No objection.
All right, state, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. After reviewing the same, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just follow the plea agreement, Judge, and sentence my client to the agreed 2 years.
2.
2 years.
Yes. All right. The court will sentence you to 2 years at the prison, give you credit for any time served. There's $1,000 fine, time and money to rank concurrently. I'm going to request a therapeutic community for you. It's to help you with any type of drug addictions you may have. I do not have the authority to force them to place you in the program, but they'll see in the judgment that I'm requesting it for you, and you'll still need to request it. Do you understand?
Yes, correct, Your Honor.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. If you don't take care of this drug addiction you have, what's going to end up happening is you're going to end up in and out of prison.
Now we hit the emotional core. Look at this. The judge isn't just sentencing, he's giving a warning with a human touch. If you don't take care of this addiction, this isn't just legal advice, it's life advice. The stakes couldn't be higher. You can almost feel the tension as Hernandez is confronted with the harsh reality. Fail here, and prison becomes a revolving door. Audience, think about this. How much impact can one judicial warning actually have?
And if you have another charge, this may not be your attorney, I may not be the judge, this may not be the prosecutors. And your minimum sentence, depending on the type of felony it is, your minimum is 25 years in the prison. Now, so you're either going to end up in prison, or either last time you use may be the last time you use, and somebody may end up having to identify your body. I know you addressed an issue with me stating that the school police office or their security have certain items that belong to you. They should have turned that over to the police, but if they didn't, you are supposed to have those items back. So you'll need to contact them. I don't have any jurisdiction to force them with anything, okay? All right, good luck to you, sir.
Thank you, Judge.
Thank you. So on each of these cause numbers, a bond has not been set, is that correct?
That is correct, Judge.
Okay.
On his two MTRs, I have a copy of one of them. So one of them is 2024 CR 1238. The other one's either 37 or 39. But motions to set bonds have been filed on both cases. And at this time, we're asking the court to set him a bond.
Okay, just give me a moment.
Yes, Judge.
All right, and are there going to be any witnesses?
No, Judge.
Okay.
The 20th.
All right, in each cause number, the court, sorry, not in each cause number. Court is calling 2024 CR 1237 and 2024 CR 1238, State versus Eric Cantu. Can I have parties announced for the record for the state?
Lauren Espinoza for the state.
Charles Bunk for Mr. Cantu.
And are you Mr. Cantu? Could you unmute for me, please?
Yes.
All right, and are you Eric Cantu?
Yes, sure.
All right, we're proceeding by Zoom with you, Mr. Cantu, because they brought to the court a different Eric Cantu instead of you. You
Yes,
have a
sir.
right to have your case
October 8th.
heard with your being present in court. So do you have any objections to appearing by Zoom?
No, Your
Defense, do you have any objections to your
Honor.
client?
We do not.
Objection to the defendant
It's
appearing
okay.
by Zoom?
No, you're
Mr. Cantu, I'm going to mute you on your end because we can hear other people talking. But if your attorney wishes to call you or testimony is needed from you, I'll
Okay, yes, sir.
at any time during the proceeding, you have a question about something, just raise your hand and we'll be able to see. And if you make sure you watch that for
I'm
his
watching.
raising of
Yes,
hand.
he's right on your left shoulder.
Okay. All right, so the defense has filed motions to set bond in each of these cause number. The charges in each of these cause numbers is evading arrest, detention with the vehicle. Defense, do you have any witnesses?
No, Judge.
All right, defense, and states, you have any witnesses?
No, Your Honor.
Are both parties proceeding on argument?
Yes, Judge.
All right, defense, you may proceed. It's your
Yeah.
motion.
Thank you, Judge. At this time, we're asking the court simply to set a bond in Mr. Cantu's 2 MTR cases. He has been in continuous custody now, since December 4th. I know the court is aware of the circumstances that led to that somewhat. And I'm not here to, at this time, contest or dispute those charges, but those are allegations on his MTR, which we understand. But on behalf of Mr. Cantu, we're requesting the court to set reasonable bonds.
All right, and what the court can tell both parties attached in the motion is the motions to revoke. So the court has reviewed that as a part of the motion to set bond. Mr. Cantu, the court does not take any allegations in the motion as true because the court has not heard any evidence in regards to that. But I do will take note of your previous conditions so that I may set an appropriate
Yes, yes.
bond if the court chooses to do so. All right, state.
Your Honor, I actually have the new offense report. Should you want to look at that, I can offer it as an exhibit. If
objection?
Defense
No.
does not object. So at this time, state would move to admit what has been marked as State's Exhibit B1.
All right, the court will accept into evidence States Exhibits B1 for the purpose of this hearing only and will review the same. All right, the court has reviewed States Exhibit B1.
And if I could, Judge, at this time, I'll offer, this is a affidavit that is in the possession of the district attorney's office regarding that case, just so the court can also be aware of its.
All right, any objection to Defendant's Exhibit 1?
No, Judge.
All right, the court will review Defendant's Exhibit number 1, which is an affidavit from the complainant who is listed, and States Exhibits B1, and it's an affidavit requesting that there be no prosecution. All right, any other exhibits?
Not at this time, just argument, Judge.
Nothing else, Judge.
All right, if you all will give those to the court reporter, please.
Absolutely.
All right, so I'm assuming in each cause number that both parties will be asking for the same bond amount.
That I don't know.
No, we're not at the same amount.
No, I mean, whatever amount you ask for will be
Yes.
the same in each cause.
Yeah, oh, yeah, I'm sorry, yes.
No, I'm sorry, it's me, because it'll
It's
make
late,
it easy
right,
for
no.
the court
It
reporter.
would be much easier if your answer, first question was yes, but it's not, so.
All right.
Yes, it's the same in both cases.
All right, so defense is your motion.
Judge, at this time, we're asking you to set the bond at a maximum of $50,000 per case. We believe that is sufficient to guarantee Mr. Cantu's appearances in court, and the courts where he's never had an issue with appearing in court. With other conditions, the court may deem appropriate, of course.
All right, so with regards to the request of the $50,000 bond, would you like to call your client to just answer questions of the bond amount he is able to make?
No, not at this time.
Okay.
Your Honor, state would be asking for a bond of $90,000 in each case. Although defense did proffer to the court the affidavit of non-prosecution we have received from the complainant, the DA's office has not made a charging decision regarding the new offense. Further, the issue is, in the state's opinion, is not that Mr. Cantu doesn't appear in court, but rather that he continues to victimize the community and pick up new offenses, allegedly. And that he cannot comport his behavior to that of community supervision, what has been ordered by the rules and regulations of that supervision. So we would ask for a bond no less than $90,000.
Here comes the classic courtroom tug of war. Defense asks for $50K per case. State pushes for $90K. Why the difference? It's all about risk perception. Defense wants access and fairness. State wants to protect the community. This is a textbook example of how bond amounts are as much about strategy and public safety as about finances. And notice the subtle psychological play, asking the defendant about family help to show capability. Smart tactics on both sides.
All right, if we could go off the record, just briefly. All right, Mr. Cantu. I'm going to ask you to unmute.
Yes.
Your attorney is going to call you with regards to a bond amount in your finances. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing?
Yes, Your Honor.
Yeah.
Lower your hand.
Yeah.
State your name for the record. If you'll state your name for the record.
Oh, Eric Cantu.
All right, defense, you may proceed.
Mr. Cantu, how long have you been in jail, sir? Since the 4th
For
of
a
December?
month.
Okay.
Correct.
Your family and myself and you have discussed the motion we're here today to set the bond on your motions to revoke your probation. Is that correct?
Yes, sir.
And you yourself, do you have any bank accounts or money in the bank under your name?
As far as right now, no, sir, I do not.
Okay. Do you own any real property?
No, sir.
Do you own a car that you own outright?
Actually, I did before, but now not anymore, no.
Okay. And am I correct in understanding that if you're able to make a bond, it's going to be with the assistance of your family? Is that correct?
Correct, yes, it is.
And your family and I have discussed various amounts. And is it your understanding that if the judge was to see fit to set the bond at $50,000 or less per case, that's an amount your family might be able to raise given a little bit of time? Is that correct?
Yes, sir, that would help a lot.
Okay, that's all I have, Judge.
Okay. All right, so defense is asking for 50,000. Any other
Yes, sir.
argument?
Your Honor, additionally, that I would just, as the court's aware that Mr. Bunk is retained, rather than court appointed, but that's all.
Okay. All right, this is what the court is going to do in each cause number. In each cause number, the court is going to set your bond at $90,000. There should be full GPS. The court will ask that the GPS fees be waived. There should be no contact with the complainant. And that will be the court's order in each cause number.
And just like that, the judge drops the hammer. $90K, GPS, no contact. This is a defining moment. The court balances safety, fairness, and legal precedent, all while keeping the process moving. For viewers, pay attention. These conditions aren't just paperwork. They shape the defendant's daily life and set the tone for compliance. This is what courtroom strategy looks like in real time, folks.
All right, so we can go off the record. And then with regards to the motions to revoke, do we have a contested hearing date for those or no?
Not that I'm aware of. We do? Oh, I'm sorry.
The normal setting, I believe, was on the 27th.
All right, we'll set it for a contestant, and then if it's not going to be a contested hearing, then we can change it, but just let probation know. So if there are any witnesses that they have, they can counsel.
So we'll keep our date for the 27th. That will be our contested date.
Yes,
Okay.
will you be prepared on the
Yes, sir.
27th?
Okay.
All right, so Ms. Abrams, it'll be a contested hearing on the 27th. Is there anything else from either party?
Not at this time.
And take your own.
All right,
May we be excused?
yes.
Thank you.